You have all seen that we have entered a new era of taxation, but your institute has thought of long ago when my tenure was in Delhi. Thanks to you all that you invited Chiranjeevi, who was also instrumental for your tax research institute in Delhi when Mr. Mahanti, Suresh Mahanti was the president. They were all in touch with me, all the three institutes being as a member of the Institute of Chartered Accountants of India. It's my privilege that I have been associated with all the three institutes and the support I get from them to build the subject and also to guide the members, educate and also reciprocate each other's knowledge. It was a very cordial atmosphere that was been with me from all the three institutes. So when this Mr. Mahanti was the president there, it was very interesting that he came to me one day. He said, "Sir, our subject syllabus is very old." So I told that, why don't you relook at your syllabus? Your syllabus needs a change. Because you were same in the prime cost, standard cost, all these era which I was reading in the Institute of Chartered Accountants of India when I was a finalist student. I said, enter into a new area and open the vast opportunity for the members that who will be practicing in different fields. So your intermediate syllabus was changed. This Chiranjeevi was also one of the co-worker with us and we all worked together for changing your syllabus. Today you are seeing the new syllabus. It is because of your all pioneers, those you have thought of. Then thereafter I found out that he requested me, "Sir, why not we go into the fiscal studies?" I said, "You should allocate a huge budget and fiscal studies is not so easy that you should embark upon that. You have to give your resource person and time." With a very small skeleton he started his working and a very beautiful literature was prepared, and Mr. Durga also has inaugurated one of the literature in our Hyderabad conference. I was very happy to see that at least they made hard labor, that valuation of works contract and this valuation of business, but I don't know what has happened to those journals. Now coming to this occasion, I am very thankful to Mr. Niranjan that who could get best compilation from Datte, who is one of the experts also in the field, both direct tax and indirect tax, and a good friend of mine. He has made a very good compilation and a very handbook for all of you. If you have all gone through that, it is a somewhat a referencer forever, because I was going through the document. So beautifully he has explained chapter wise, of course not in the pattern of the legislation what that is given in our statute book, but even then he has explained very well. Now coming to the assignment given to me, I can say that we are still in infancy stage without now looking very excitedly into the dispute area, but the basic jurisprudence of the prevention of litigation and also reduction of litigation I may highlight upon you. If you have gone through the various phases of our economy, we have seen litigation have been developed within 4 or 5 years of the implementation of the law. From 1922 law of income tax, we embarked upon 1961 law. Similarly, from 1913 Companies Act to 56, now we have entered the new area in 2000s. So in these phases, we have seen the different evolution of the law, because law is made with the changing needs of the society, is not static. Always you should remember, when you are entering into the fiscal studies and also the fiscal statutes for the purpose of practice in your profession, which has a vast opening area, and very few people like Mr. Bhatt, I was told that they have shown their interest in this particular subject for practice. It is definitely a good space for practice, because of direct taxes people have seen, tested, and also many of the cost accountants have also have their expertise, particularly in the transfer pricing system. I have seen many people, because I have an opportunity addressing in various national and international seminars. I have seen that. Many of your members have so good a contribution to the profession. They have found out what are all the intricacies to be examined from the cost angle, while this financial chartered accountant, he examines from the financial aspect, and they both give the input for the purpose of the legal fraternity for examination of the issues involved in a dispute. As Mr. Mahanti has very rightly said, the subject is very vast, I do acknowledge, and if you are able to read in a very microscopic manner, the subject is not vast, because you have vast experience in the taxation law of income tax, and those who have practiced in sales tax, you have also very good practitioners I have seen throughout the country. Central excise, you have equally good practitioners, I have seen that. So you are all well conversant with the meaning of manufacture and meaning of the valuation of the goods, and many of the valuation aspect your institute was contributor in the budget compilations. And few of the budget compilations what you have institute has given, where I was also participant, we have seen many of the proposals have been accepted by the government. So now, this particular subject of the GST, no doubt, it generates an interest because it has subsumed many of our indirect taxes, reduced our burden, and it is not at all, I can say, an exception to the basic fiscal structure and fiscal studies. If you see the first part of the law, that there should always be an incidence of the levy, that is how the levy shall be on the subject, because Constitution does not permit any levy without an authority. Those who have practiced income tax, they must have seen section 4, that without an authority under the Constitution and that has been conferred on the legislation to make a provision for the purpose of levy and recovery, there shall be no levy. So in the first part of the statute, after soon of the definition, they have made a schematic provision there, how they will propose the levy. Of course, as Mr. Mahanti said, initially we will have lot of difficulties for which you go for repair, remodeling of the houses. In the similar manner, this law is undergoing its metamorphosis and also it may have a change. There is no doubt about it, and legislature may be also aware and they will also be getting experience from the profession to go for various amendments and changes. If you see it, the scheme of the levy is really in section 9, but they started scope of the supply in section 9. It is somewhat, if I be a good reader, this is not in accordance with the proper legislative practice, I can say, because the normal legislative practice is what legislature intends, they first speak. Of course, through the definition they say what are the terminology they are going to use in the whole scheme of the law, and through that particular grammar they give you and also the dictionary they give you to find the meaning of the entire legislation. They start with what they intend to do. So their intention is that to levy GST, that is, as somebody was also at the initial stage of introduction was saying, that this is a concurrent levy, because in order to reduce the dispute, to make the law more simpler and implementation friendly, they made both the laws in a harmonious manner, that the central sales tax, that is the central GST, and also this state GST will be in harmonious manner. Therefore, the section 9, which has been designed to first tax, what is to be taxed? Supply, express supply and implied supply, they have stated. So this particular section 9 is requiring a total debate throughout the country, because this is one of the sections which may give rise to dispute from the past experience in the legal profession, I can say. Normally what the legislature do, what they expressly state, they state in the section, when they propose to do, they do in the deeming provisions, and what they intend to do, elaborately they speak in different schedules, which you have found the generation of your schedule is beginning from the section 9. The exemption notification, deeming provision, the negative list, what you have found that what is not to be taxed, they have also been included here, what is not to be taxed. Therefore, in a schematic manner, if you understand, you try to understand the law, the first thing is you should understand that what is intended to be taxed and not to be taxed by express provision of law or by implication. Because the basic jurisprudence of understanding tax law is to understand the letters of the legislature. There should be a strict definition of the liability and nothing to be in a very evasive manner or in arbitrate manner. There should be a very express provision that what they intend to tax, and while they say it, if you go a little deeper in a very common sense approach, when they supply they intend to tax, that there should be two persons, one should be recipient and another is the giver. Here is the supplier and recipient. If we go a little back, our Finance Act 1994, this concept was introduced, while you can't appreciate from the Central Excise Act 1944. Central Excise Act does not intend at all who shall be the buyer. So therefore, with vast experience, difficulties, and also with the requirement of the present environment, society and economic needs, they have designed this particular law, of course, in a hurried manner, I can say. Because if you see the even harmonized classification, let me give you the basic background of the taxation here. Supply is the basic criteria for taxation. If it is proved that a particular transaction between two persons has resulted in supply, which was not earlier in the sales tax law. Sales tax is a transaction of sale, occurrence of the sale as defined by Sale of Goods Act, and in a very little modification defined by the sales tax of the concerned state and also Central Sales Tax Act. In the similar manner, supply being the criteria that gives rise to the incidence, here goods is not taxed. There should be no confusion about it very clearly. Here is not a goods taxation law. It is a supply oriented taxation law, both of goods and services. So there should be the first of a proof of the supplier and the person who has received. Therefore they say at the opening also, this is consumption based taxation. This particular thing was also borrowed by legislature from All India Federation of Tax Practitioners judgment of the Supreme Court, when the Supreme Court said that indirect taxes should be the consumption oriented tax, and also it should be at the last point. Of course, this law has made an effort that there is no these multiple taxation like the state legislations in different sales tax laws, that first point agricultural goods, forest goods, all those things they were taxing at the first point because they should not escape from the taxation and cause evasion in future. But those structures are not there. Probably they have thought of that if at all it, at the end, that is the consumer end, where these prospective business aspect they have considered and they have done that. So supply aspect, section 9 read with the scope of supply is definitely an area, but let us not have an apprehension till we get the dispute. These are all the areas where the dispute would come. Then if you first see section, this chapter 3, that is 7 to 11, 9 and 7 to be read together, 8 and 10, that is all your composition scheme of taxation, which is already people been aware of, both in service tax and also in sales tax law, those who have dealt with the works contract taxation. But here is a composition scheme, very nicely they have introduced here, in probably with revenue elasticity and also the dispute reduction object and ambit. So these are the first chapter, this is chapter number 3, and this section 11 what the deal is exemption aspect. While the exemption is granted, you are all aware that government gives the exemption wholeheartedly certain things for the boosting of certain sector, boosting certain commodities to grow, boosting certain people to be involved in business. There are various criteria depending on the object of the statute. So here exemption is granted. This is also one of the area may give rise to dispute. While claiming exemption being accepted, you must be thinking that you will be getting the benefit, but people forget that many of the exemptions are general and also many are absolute and conditional. This is all the experience economy has seen in direct taxes and even central excise, customs and service tax. This is nothing new to this law. Therefore, if somebody is well convergent with section to 7 to 11, he will be a very good practitioner, there is no doubt. And all other provisions thereafter you find, because the dispute area I can say precisely 7 to 21. 7 to 11 your chapter 3, then 12 to 16, that is all your this supply, time of supply and the place of supply. That is also one of the dispute area which we have experienced in the Finance Act 1994. Who supplies, when supplies, where supply is done, because this has a direct relevance to the integrated goods tax system, that is the earlier central sales tax law. Plenty of the disputes economy has seen, and those disputes are when the supply started, where the supply terminated. Here is the supply, intrastate is the subject of the matter of the state GST and central GST, and interstate is the subject matter of the integrated taxation system, where we found that from one state to the another supply goes. This is also one of the area, as I said, from section 7 to 11, it needs in-depth study for reduction of litigation. Those who are in the corporate structure, it should be their duty every day that section 7 to 11 is to be mastered for the purpose of reduction of litigation. Then thereafter when you enter the other arena, that is all these bundling of the service, bundling of the tax, what we have already been seen in this previous era of this Finance Act 1994. So when you go through that, soon after 12 to 16, 12 to 16 is equally is your dispute area. 12 to 16, as I was this book, your literature that has also very nicely complied, is the time and value of supply. because particularly when the time of supply was the question in service tax, those who have dealt with the foreign exchange and also import of service, export of service, there were huge time being lost by litigants that what shall be the date of provision of the service and incidence of the levy. Finally, government replied that when the foreign exchange comes, that shall be the incidence of the levy and also that shall be the liability arises only at that point of time. Even 12 to 16 is not free from the disputes. When coming to 17 to 21, which is your input area, that is Senvad credit, which was having plethora of litigation, now even in Supreme Court and various forums, this is also nothing a dispute-free area. Because what is input, how to be set up from one put to another input, how to set up, who shall be eligible to that, plenty of litigation this economy has seen. So my request is that to avoid litigation, one should be very clear in his mind that he should not be excited to claim and he should reduce his mind to the particular provision and object and intention of the legislature, that whether they intended to provide the benefit or not. If they have not provided, then better not to do that, because litigation cost is very costly, and as a cost accountant you all know that its implication is very serious. Those who go for world tender, they face lot of difficulties, any tax due pending. Apart from your 44 AB audit report in income tax, you face lot of difficulties and you are bound to disclose in a joint venture project tendering that this is your tax liability, so that the other stakeholder will understand you better. So your 17 to 21 area is another dispute area. We do not know what shall be the situation, because soon after the audit starts, and also the adjudication process starts, the difficulties may be very faced and experienced. Therefore, with all this background, what this topic you have chosen is prevention of litigation, litigation management. This is actually a very serious thought every day by the top management. Many companies I have seen, management practice as a consultant to the World Bank projects. This is my experience, that how to reduce litigation, no arbitration should come, and we should not have supplementary bill or the exculpatory bills. In exculpatory bills, what you have incurred, there may be certain incurrence, physical incurrence, and there may be notional incurrences. All these difficulties create a problem and huge money is involved in litigation. The first step for the purpose of prevention of litigation is that try to have a mastery over the very incidents, compliance area, then what are all the exemption area, proper interpretation area of classification, and determination of the value of the goods. So 7 to 21, if you are able to master over these sections, 15 sections, that will definitely reduce the litigation in this particular arena of the law. Now, so far as the litigation management, so if the litigation arises, what are the strategies now the management usually adopt? This is also one of the interesting area where now the litigation experts are chosen by many companies for their appointments. There is a scope for many of the good consultants to get good assignment in those areas, because the cost benefit analysis has already shown in the economy that litigation is very costly and litigation is defamatory, litigation also loses the reputation. So where the litigation cost is very high and compared to the time consumed and also the cost involved, it is better to forget and pay the taxes. If you have paid, the interest and penalties are the consequences for default. At least that way you can reduce, and that much of reduction will be also able to stimulate you for the purpose of growth, instead of only roving around the lawyer's office who will be giving you the promises that I will win the cases. Be clear and be sure whether you have a case or not. If you have no case, don't look to the face of the lawyer, a big lawyer or a big designated person or a very big experienced lawyer, all these things. That will have no consequence and help to you, because this is all of my experience in one side as a practitioner, other side as a appellate authority. So if you are going to the lawyer with excitement who gave you a lot of promise that you will win the cases, examine thoroughly and also logically. Because this litigation cost I have seen sitting on the bench is so severe. Suppose the case is adjourned, your cost is not free, it is costly. Case is heard after 5 years. If the liability is confirmed, interest grows, Penalty may be severe and you will not have the purchasing power to sacrifice. Suppose the other round, if you see that, if the matter is remanded, goes to the adjudicating authority recomputes, and adjudicating authority does not give you relief, again you go for the purpose of litigation. This will not serve any useful purpose. So prevention of litigation should be one of the objects. This is all the present management and very MNCs now always they see what is the chance of success. If chance of success is low, cost is very heavy, better not to resort to comply, and upon compliance you can go and litigate. But without making compliance to the litigation is very, very dangerous. Interest shall follow and penalty will be severe and adjudicator will not be at all lenient, and in many of the provisions of the statutes, provisions are made, usually no lenient view is taken. Because you see, if you have where in practice in the excise law, in many of the provisions you have seen that, with our experience we have suggested also government to a great extent, that if you reduce the penalty and in a graded scale depending on the demand and depending on the time of compliance, you can give some reduction so that the compliances will be ensured. That has resulted very well. In 2016 they made amendment, 14 some amendment, 16 some amendment, that has helped a lot. So I won't kill much of your time because the subject is very vast, as Ms. Mahanti has said, very rightly he has said, we cannot apprehend any dispute that may come, or we should not also welcome these disputes should come. Because particularly when this law was made, it was basically a compliance orientation law. That was the designing, if you see the entire structure. Initially people will say how return is to be filed, how these things will. This is a normal anxiety everywhere when the law is introduced. When Saral form was introduced in income tax, people were very happy. But even to design Saral form, people do not know that what sort of time government has taken. So let us not be apprehensive, let us not be also excited. Dispute will come. But the basic philosophy of reduction of dispute is one should be aware of the provisions of the law. He should have attitude that he should not be involved in time consumption and resource management, should be so prudent that he should not waste his resources. Manpower is very costly, time is very costly, even money is very costly. Even many a times when the bank appraisal is made for the purpose of funding, bank always ask how many litigations you have, whether labor, environment, taxation, or even in these employees' welfare. In those circumstances, bank, they are very keen that if this man's history is litigation and in which year the litigation was done, it is continuing, they are reluctant to fund. So many aspects one should see that and have the approach. First, to have the comprehension of the subjects in his mind, to be a good advisor on prevention of litigation and also litigation management. Thank you very much for the opportunity you have given me, and I hope that you will continue with this effort of your debating on various aspects of this law and also to have very technical understanding of the subject. Thank you all.